super excited to have him for our luncheon. We're going to be doing his presentation, and then we'll leave some time open at the end for Q&A, and I'll walk around with a microphone. So feel free to save your questions for the last, and we'll turn the time over to Rob. So.
Thank you, Heather. Okay, thanks everyone for coming out today. I very much want to make this a two-way discussion. So if you have questions and I can hear you, then feel free to raise your hand. I'll call on you, and if not, we can wait till the end and pass the microphone around. And if we run out of time, I'll hang out as long as necessary, make sure everyone here gets value out of this conversation. So we're here today to talk about patent protection of AI innovations. And the topics we're going to cover are what qualifies as something that can be patented, who owns the AI-generated work, how should companies navigate AI-generated IP, and how startups can compete and protect their AI innovations. Okay, so what qualifies? We got to get a little bit of legalese going here. If you ever participate in a patent process, you'll be familiar with some of these terms. But officially, what's patentable is a new, useful, and non-obvious process or machine, or a new, useful, non-obvious improvement to an existing process or machine. So some examples: improvements to the functioning of a system or other specific technology. The Patent Office really views a system as something that requires hardware. So while there has been many publications from the Patent Office and case law decisions that require the improvement to be to the actual hardware, there are ways to get around that, especially if we can focus on some other specific technology that's being improved upon. Another example is affecting particular treatment or prevention of disease. So in the AI space, any AI that contributes to this could be considered other specific technology. This next one is a big one, especially in anything that includes AI or software in general, is include a specific limitation beyond what is well understood, routine, and conventional. So AI specifically, this note below, more recently in the United States, simply training a generic AI system or model in a new data environment is considered well understood, routine, and conventional, and is therefore, according to the Patent Office, not patentable. However, this next bullet, including a meaningful constraint or limitation on the application of an AI innovation, is the way to get around that. And I've personally had some success, and there have been some big case decisions where success has been made by doing exactly that. So although the Patent Office likes to say you have to improve a model to be patentable, that is not true. It makes it easier, but with enough work and enough meaningful constraints or limitations in the patent application, we can patent things that don't necessarily improve the model itself. Okay, what is not patentable? Mathematical relationships. So those who innovate in math have a difficult time, but it's not impossible. We simply have to add those meaningful limitations and describe the innovation as a process or a method or some machine that calculates the mathematical model. So we can have math in a patent application, we just can't patent the math itself. Similar with fundamental economic principles. So this really goes back to what is well understood, routine, and conventional. If we're taking a conventional economic principle or practice that was done off of a computer and now putting it into a computer, even if we use AI agents in that process, that's not patentable in and of itself, unless we add those meaningful constraints like we discussed earlier. Very similar with commercial or legal interactions. So the Patent Office will say that these aren't patentable subject matter. However, there's tens of thousands of issued patents out there in advertising and marketing. They're just detailed enough to limit the scope of the patent to solving a particular problem or in a particular technological area. Similar with managing personal behavior, and this includes social activities. Again, tens of thousands of, maybe hundreds of thousands of issued patents in the United States covering social media, right? So those are social interactions, but its limitation is a social media environment. Yeah.
So on the last slide, you said it is patentable when you narrow the focus and when you set limitations. Is that essentially just saying, instead of saying something that's going to cast such a wide net that it's unenforceable, you're limiting it down to something very specific? Is that where you can get in kind of around these items?
Yeah, that's exactly right. The Patent Office wants to see specifics. So, like for example, with this managing personal behavior, we can't patent a human interaction, right? But if we take that human interaction and add a lot of limitations around that human interaction, what type of technology is required, what type of messaging is required, is there processing done in the background that's specific to that human interaction? Well, now we're taking a human interaction and we're not simply computerizing it. We're creating an algorithm and a specific limitation on a specific technology, right? So a lot of these are not cut and dry, but if you work with someone who has experience in these, it's a little bit more open than what the Patent Office will like to communicate. So this next one is a real big one in all software arts, including AI. The Patent Office will call this an abstract idea, a process that can be performed in a person's mind or by a person using pen and paper. So if you have a really broad innovation, it's best when we start the patent application to put in lots of specific examples to narrow it down in case we need it to get past an abstract idea rejection. And if we can get past that, we might be able to broaden it in the future, but it's best to start the conversation with a patent examiner on not being so broad that they just get turned off to everything else we're going to say throughout the rest of the case, right? So here's one that's specific to AI, application of conventional AI to a new data environment without improvements to one or more models. I mentioned this on the previous slide. And again, we don't have to improve a model to be patentable in the AI space. I've had success doing exactly that. So while it makes it more challenging, it's more of a slam dunk if you improve a model. But if you're using multiple models in a specific way with specific outputs to solving your specific problem, then there's a way, that's the way to get around this requirement. Okay, so before we go on to the next topic, we need to do a brief dive into inventorship. And an invention is conceptualized when it is sufficiently formed in the mind of the inventor to describe how to make and use the invention. So in most nations, the patent process is a trade-off. You are essentially applying for the exclusive right to make and use your innovation for 20 years. And in exchange for that right, you're teaching others in your field how to make and use your invention so that they can improve upon it, right? This is the spirit of innovation. Now, if they implement it and they infringe on your patent claims, then you can put a stop to them or require licensing or some other type of compensation for that, even though they might get a patent on the improvement they made on your innovation. So that's kind of the difference of what can you make and use, what can other people do, and what is patentable. They're not always the same. If two or more people share in this original concept, then they are co-inventors. And this is a big one for employers. Contribution to the reduction of the invention to practice does not constitute inventorship unless the original concept of the invention changes. So what does that mean? If you innovate something and then you hire someone to implement that, whether it's coded up, develop prompts, develop some process using AI agents, the person you hire is not a co-inventor. unless throughout that process you decide to change the original concept and that person that you hired or team that you hired winds up participating in changing that original concept.
How much does that concept have to change? Because most ideas, especially in software, they start out, with one idea. By the time you're finished, it's been refined. Some things have been reduced or added. Where's the line for that?
Yeah, that's a good question, and there's no definitive answer. It really depends on what the innovation is, based on what else has been published previously, and does the core of whatever is new and non-obvious that's been brought to the table, was that changed or not? There's lots of case law out on this, so it's really a matter of somebody who's skilled to analyze your situation and give you some advice on that. And the reason we're talking about inventorship, this last one is the big one. Improper inventorship may result in a granted patent being declared invalid, which is essentially unenforceable. So in my world of doing patents, to me, this is the worst case outcome. We put all this time and money into developing a patent application, pay all the fees to file it, pay all the fees to prosecute it with the patent office. The patent office finally agrees that it's patentable and gives us a patent. More fees are paid. Maybe maintenance fees are paid if you've had the patent for a while. Somebody infringes on your patent and then takes you to court, and it's argued that your patent is invalid because the inventorship wasn't correct. It's as simple as that. And now you've lost everything. All that time, all that money, all the protection you hope to have. So it's really important to get inventorship right. If any of you are ever in court over a patent dispute, the opposing counsel, this is the first thing they'll look at because it's the easiest way to kill a patent. So having the inventorship correct is paramount. There are other reasons that patents can be invalidated, but they're much more difficult than improper inventorship. Yeah.
So if you mentioned specific AI models like ChatGPT 4.0 or whatever, are you stuck to those models? Like, obviously, you're going to want to update your models as AI evolves. Does that mean you're stuck to those models? If you update your models, does that invalidate your patent?
So that depends. If you're using a type of model, then, and there are many examples, like let's say your innovation requires a large language model. Well, there's lots of large language models out there. So instead of naming them by name, we will just put the minimal detail needed to show that it's a large language model, right? So, but innovation continues. There are times when a company continues to innovate and now their former patents aren't as applicable anymore. Someone can still knock those off, so it's good to have that protection. So when you're doing lots of innovations and lots of improvements, it's best to just keep filing every time you have a patentable innovation. And that way you're covering the past and the future. And remember, utility patents in the United States are good for 20 years. So a lot's going to happen in the next 20 years, right? And even if your patent is only applicable to current technology for 3 to 5 or 7 years, then at least you have that runway for the next innovation, right? So does that answer your question? Okay.
What's an example of the inventorship going wrong? You mentioned that's the easiest way to kill a patent. So, what would that look like if that was not set up properly?
Yeah, so it's one of two scenarios. There's an inventor or a co-inventor that's not listed, or there's someone listed that wasn't a co-inventor, right? So I've seen big corps make this mistake before, where they'll put all the people in the department that came up with the idea, or they'll put the innovator, the innovator's director, the innovator's VP, right, the CTO, all on the patent, even though all of that management may have not participated in the original concept. So that's a very easy way to kill a patent.
So their contribution has to be enough to be listed as one of the co-inventors to kind of redirect the end state. But if they didn't do that, then it makes it invalid.
Yeah, it could be invalidated. someone has to find that out, right? So on all patent applications, there are multiple entities. There are the inventors, there are the owners, so that might be a company or someone else who paid for everything, and the inventors made the decision that they would assign the rights to a different owner. And then there's whoever is applying for the patent application, and that can be either of those parties or another party altogether. So it's important to identify all of that. Yeah. Yeah, discovery can include all communications around the patent. It can include interviews. So when we get to the next slide, I'll talk about how we can try and get around this and protect ourselves. But if they interview each of the co-inventors and say, okay, what was your contribution? And someone says, well, I didn't do anything. They're just my employee, right? Obviously, that's going to be a problem. Yeah. Yeah, so notebooks used to be a lot more useful than they are now. So in the past, prior to 2012, the US was a first to invent system. So all of the notebooks, all of the emails, anything else that could be documented could assist you in proving that you had the invention when you had it. Could also prove to the patent office that you had the knowledge to be able to do all this. That's changed. So now we're a first to file system. So basically the patent office assumes that all of your knowledge around your innovation is in your patent application. So yes, I think the notebooks are valid, but it's a matter of transferring the right information into a patent application, because beyond a person having ordinary skill, all that you know around your innovation needs to be in the patent application. Okay, so who owns AI-generated work? This is why we went down the inventorship dive. So under current US patent law, inventorship is limited to natural persons only. So for AI-assisted inventions, the inventors are those who significantly contributed to the invention. And use of an AI system in creating an AI-assisted invention does not negate a natural person's contributions as an inventor. So this has come up recently, and there's been a big debate about this in the patent office, so I don't expect this to change. A significant contribution could be shown by the way a natural person constructs prompts. So constructing prompts to solicit a specific solution to a specific problem, especially in a technological area, that can be patentable, and the inventor is that natural person who constructed those prompts. As a patent practitioner, I look at this as basically part of an algorithm, and those prompts, if they're novel, are part of the algorithm. Natural persons who design, build, or train an AI system in view of a specific problem to elicit a particular solution could be an inventor. Go ahead.
Does that also include like natural people who work at OpenAI developing ChatGPT? You know, they're building a tool that helps you build this solution. Are they ever involved in that last statement?
I think it's possible. That's where it gets tricky. But do you have a business relationship with them? Right? I think I'd have to dive into that a little bit further if it was a publicly available tool, if that contributed. I'd really want to avoid that. I would much rather focus on all of the innovations that were done by you and your team or your company, right? Right, right. And now the patent office thinks an LLM is just a generic, non-patentable innovation, right? So we have to dive into more details of improvements to the LLM for it to be patentable now.
Are you saying that the prompts themselves become patentable, or the result comes out of the
Yeah, I think it really depends on what's novel, but the prompts themselves, if it's inputs turning into outputs and the prompts are part of the input, that could be the novel aspect.
The reason I ask is because there's a lot of APIs that are built for they're being integrated with OpenAI and underneath the hood, there are prompts that are driving that. So if somebody develops a piece of technology and says, hey, I want to patent these prompts, are we saying that if somebody else has a prompt that looks like this sentence, looks like that one, our software that does either the same thing or does something different, that all of a sudden we've got some sort of contextual patents?
I don't think so, because there normally has to be a bit more to it than that in the patent claims. There's going to have to be something about what is the input, what is the data, and then how is that data organized, changed, manipulated, whatever, and what is the output. So the prompts are part of it, but it's not all of it, if that helps. Yeah. Yeah, that is a challenge, and I actually have a slide on that. I think it's the next one. Yeah, so we're going to talk about this right now. Hopefully this will answer your question. If not, let me know. So how do we navigate all this? And the key is documenting potential inventorship. So I suggest you note everyone who develops concepts that are implemented in any AI system or model. Note everyone who constructs the prompts to elicit a solution from an AI system. Note everyone who designs, builds, or trains any AI system or model. And this is the key, mapping all possible inventors to all of the AI-generated innovations. It's better to have a list of people that might not be inventors than to leave someone off. Because a patent professional can take this list and then, after the claims are developed, narrow down who the true inventors really are. So it's a lot of documentation, and I know this is challenging because there's innovations being developed all times, but if there's a person at each company doing this, it would make things a lot easier for patent protection in the future. Yeah.
On that first one, everyone who develops concepts, does that include people like you do interviews for, like you interview a potential customer to get feedback on what the system should do, and if they give you a really good idea, then like, do you have to note them down? I did that once with an interview.
Yeah, that's a great
Concept, and they said, no, just this is what's really necessary.
Yeah, so that's a great question. In that type of scenario, the customer is really the innovator then. And they're basically hiring you to reduce their innovation to practice. So they should be the one going for the patent protection because they own it and it's their inventors. It's really it becomes really messy, not impossible, but really messy when you have employees from multiple different companies innovating together. It would be best to separate those and have company A doing their innovation and company B patenting their innovation separately. It's not impossible, but it does get messy. Normally, what I advise in those situations is having some kind of common entity that owns the patent, and then that way there are employees under that common entity. Okay, another key aspect to this documentation is sound written agreements with employees and contractors regarding intellectual property. So assignment of IP, who actually owns it. It shouldn't be the employees, right? It shouldn't be the contractors that you hire. Also, sound written agreements would include mandatory cooperation for all inventors, because they're going to have to sign paperwork at some point when we file a patent application. And a third key item to sound written agreements is if any of these employees or contractors leave the company or you no longer work with them, it's a matter of them being obligated to keep you current on their current contact information, so that if something does come up in the future, they can be contacted and they'll cooperate with the patent process. There are ways to get around non-cooperation, but those ways rely on a sound written agreement. Okay, so enforceable patents. We need to do a little bit of legalese here before we get to the next topic. Less than 60% of all utility patent applications are granted in the United States. So of all the patent applications that are applied for, it's high 50 percentile that is actually going to be granted a patent. So almost half of the patent applications that are applied for are rejected in a way they aren't overcome, and patent protection is never the outcome. On average, each issued patent had patent claims that were rejected over 3 times during patent prosecution. So this is really important, especially for first-time inventors. Our patent application is most likely going to get rejected. It's most likely going to get rejected multiple times. That's just part of the process. I've had some clients that don't understand this and they get totally disillusioned when their patent is rejected. It's just part of the process, and actually it makes for a more sound patent when we face these rejections and overcome them in an intelligent way. Not all granted patents are enforceable. So this is an example we talked about with the inventorship. We might have a granted patent, but if we didn't get the inventors right and some opposing counsel in the future figures that out, our patent might be invalidated. So although getting a granted patent is key to patent protection, it's not the end goal. Our end goal is to have a patent that's so enforceable that if anyone ever infringes upon it, their opposing counsel says, honor the cease and desist or pay the owner, because there's no way we're going to beat this in court. To me, that's the biggest win, right? Worst case scenario is our patent becomes invalidated. Best case scenario is we avoid the courtroom because our patent is so sound. So patents need to be enforceable to effectively protect covered innovations. Okay, so how do we create enforceable patents? The key and the foundation to all of this is a patentability search. And this is something that all of you can do before you hire a patent professional. There are patent professionals that spend a lot of time doing this, so it's not something you have to do. But if you're in a jam where you want to start the patent process and you don't have the funding, or maybe you haven't found a patent practitioner yet that you want to work with, this is a great way to start. Search for commercial products and public disclosures related to novel aspects of the innovation. The most inventors that I work with know their space very well. They know all of the competitors, what they're doing, what they're producing, what they're innovating. However, sometimes there are hidden disclosures or disclosures that you may not have seen before in a technical paper. So it's worth doing some searching. Just because a product or service is not out in the marketplace yet, and it's something you believe you innovated, it's worth doing a deep dive to see if anyone has disclosed something similar before. Another aspect of the patentability search, obviously, is searching US and international patent databases. So around the world now, when there's a novelty requirement, it's novel over any publication that exists prior to your patent filing in any nation, in any language. So you may know the US space that you are playing in very well, but you might not be familiar with what's happening overseas. Yeah.
This is actually not a joke question. It's a very serious question. So we can train an AI to do all of that
Yeah, so, okay, thank you. So as of now, because this is an ever-changing space, there are professional search tools. I subscribe to one of them. They have an AI assistant for the search. It is helpful, but it's not as great as they say that it is. So my mentor, Charles Eldering, recently did a blog post on several different aspects of AI tools in the patent world. One of them was this patent search. And he selected his #1 searcher that he's ever worked with to search on a invalidity study, and he came up with his 10 favorite related patents. And then Charles subscribed to 7 different professional tools, the top 7 in the world. One of them is the one that I use, and used their AI agents, and none of them came up with any of the 10 that his favorite searcher came up with. So they're just not quite there yet with the patentability. The AI tools in the patent space that are very good are the ones that are doing proofreading and looking for patentable aspects of a patent application and the proper support and the proper labels on all the drawings, all that sort of thing. That's very helpful. The AI tools that draft patent applications are absolutely terrible. So it's like using a large language model to describe, something that you're technically familiar with. So while I anticipate there'll be improvements in all those areas, they're just not there yet. Yeah, it could be. I don't know. I mean, I've been working in this space since 2012, and in 2012, we had a lot of clients that came to us with an AI-generated report, and within a day, we would basically go back to the client and say, okay, well, the $200K you spent on this AI-generated report is completely useless. So they were trying to do it in 2012, and here we are 13 years later, and they're not there yet. They're a lot closer, but I don't know of any AI tool that I can rely on the AI completely for an aspect of the patent space yet. I have a feeling they'll get there with the searching. The proofreading is I think is there. The drafting, they're still a long way away. Okay, so next step in the patentability search process is looking for possible relevancy to novel aspects of the innovation in the search results. So the patentability search tells us 2 main things. One, is it worth moving forward with a patent application? It also helps us fully understand what's novel. You may think that everything you're doing is novel, and let's say your algorithm that we're going to try to patent that embodies your innovation has 5 steps, and we think all 5 steps are novel. And then we go find that 4 of those steps have been done before, and really only 1 step is novel. We're going to put a lot of effort into your patent application around that 1 step, because we want to show the patent examiner that indeed this is novel over everything that's been done before. And then the last is working with a patent professional to analyze your innovation and the search results to determine if a patent for your innovation is feasible. Most of what I'm focusing on here is having a patent that's enforceable, which is adding value to your organization through the ability to protect your innovations. There are other reasons why some people get patents. There are some companies that think, well, my competitor has 100 patents and we only have 50, so I want 50 more, right? They're not really going for enforceability. That's a nice to have. They're going for the number. Some people are proud of their patents and want a plaque on the wall that shows the cover sheet of their patent, and they're not as worried about the enforceability. So there might be other intrinsic values that I'm not addressing here, But as far as having a enforceable patent that will protect your innovations, the patentability search really is the foundation to that process. Okay, critical components of enforceable patents. A little bit more legalese here just so we can get to the next section. A well-described invention in a patent application must include a written description sufficient to show that the claimed invention was indeed invented as of the filing date. So getting back to what we talked about before with the notebooks and all of your knowledge being in the patent application, we need to have a sufficient disclosure to show that the inventors did indeed understand how to make and use the invention. The invention doesn't have to be made. It doesn't have to be utilized. It doesn't have to be completed at any point during the patent process. We just have to show enough detail to show that it could be made and used in a useful way based on the information that a person having ordinary skill in the art of AI would know, plus everything else that's in the patent application. So enablement is another big one as a requirement in US patent law, and that is enabling any person skilled in relevant fields to make and use the invention. So this ties into what I talked about earlier with the trade-off between your exclusive right to use and teaching others how to make and use your invention in a way that could be improved upon.
Can you go into that more? Because it sounds like, in my uneducated head here, it sounds like somebody else is using my patents, then they're also infringing on it, which doesn't sound like it's the case, but that's where it naturally go.
Yeah, so let's say we go back to that example of there's 5 steps in a process that embodies your innovation, but only one of those steps is the true novelty. And we have a patent on that. And someone else comes around and they change one of the other steps. Or maybe they add a step to it. Now, if they change one of the other steps and it's significant change, they might not infringe on your patent anymore. But if they add a 6th step and they still have to do all the 5 that we have in our patent claims, they might get a patent on that 6th step. But if they build it, you can go after them and say, wait a second, you owe us for doing the first 5 steps. So, like for example, I used to be in the wireless space, and each one of our cell phones has tens, maybe even hundreds of thousands of patents associated with it from all different players. And about 50% of the cost that you spend on a cell phone goes to pay patent holders. Some of them are in groups where they share all the innovations and share all the profits. Some of those are individuals. So you can have a patent that is protecting your innovation even though others might be improving your innovation. If that makes sense. If they work around it, then your patent may no longer apply. But if they add something to it, then your patent still might apply if they make and use it. Yeah.
How different does your process have to be from an existing patent for it not to infringe?
Well, yeah, that's a great question. And there's no real definitive answer. Each case kind of has their own unique story. And it really comes down to how much detail was in the patent application and saying the right things during prosecution and not saying the wrong things. The more we can show distinction between what you're doing and what someone else might be doing, the better our chances of defending it. But there's the trade-off. If we're in a rush to get a patent filed because there's going to be some deadline, whether it's funding or a product launch or going public in some other way, we might not have the time to put all that we want to put in the patent application before we file it, right? So that's where the patentability search really helps. So we can focus on, I don't have to go into painstaking detail in our example of 5 steps if only one of them is novel. I just want to go into detail on that one step.
Can you amend a patent? To your point earlier, like maybe rush, maybe you realize it's maybe lean to defend and
Yeah, so once we file, we can't add any new information. We can correct mistakes, and we can also claim different aspects. So if we go back to our example of 5 steps, let's say 3 of them are novel. No one has ever done 3 of our 5 steps before. So we can only claim one invention in each patent application, but if we put enough detail around all 3 of those steps, and let's say we file a patent application and we include all 5 steps, and then we decide after going through the prosecution with the patent agent or the patent examiner, we understand what the patent examiner thinks is novel about our case, then we can file what's called a continuation application, which is basically refiling the same patent application and just changing the scope of protection to maybe only one of those steps. And maybe we do each one on its own. So at the end, we have 4 different patents. One is all 3, and one covering each one of the novel steps, so that we just broaden our protection that way. I've had a lot more success starting with narrow claims and then broadening it from there. So there's another aspect. We might do something very narrow, so we educate the examiner on exactly what the innovation is. We get the examiner's opinion on why the examiner thinks it's novel and non-obvious, and then we take out all the other things out of the claims that the patent examiner didn't mention and file a continuation with a more broad version of the claims. It's a lot more, I've had a lot more success going that way than to start with something broad, because then we put it in the examiner's mind that they don't have something that's innovative. And I'd much rather start with a better conversation with the examiner that we do have something innovative, and then we can broaden it from there. So more detail is almost always helpful. So another requirement in the patent world is, especially in the United States, is disclosing the inventor's contemplated best mode of carrying out the invention, even though the best mode does not have to be identified. So if you had a way of developing an algorithm that embodied your innovation, maybe it uses one model, maybe it uses dozens of models, and you decide to give someone like me 3 different examples of how your innovation can be utilized. But your favorite way, and the way that you want to go to market, is left out of the patent application, that could invalidate the patent application, an issued patent. So the best mode has to be in there. You don't have to identify which the best mode is. So in other words, that trade-off of we get a 20-year exclusive right to make and use, but we're teaching others about our innovation, we can't hold back the best aspects of our innovation. So that's the reason for that law. And all patents, eventually patent applications that go through prosecution with the patent office have to conclude with 1 or more claims, particularly pointing out and distinctly claiming the subject matter which the inventor regards as the invention. Yeah.
So when you file a patent, you get a provisional patent pending. Okay. With that in place and your patent's denied or it's refused, do you lose that patent pending if you resubmit the patent with the alterations? Like, are you logged in at the date the initial patent was filed under that first to file law, even if it's rejected and amended, and then resubmitted? Or when you resubmit it, does it restart that process where somebody else could have snuck in their identical or whatever patent?
Close enough, yeah. It restarts the clock. Because in order to refile, you're going to have to include a new innovation, because now your previous application is blocking your novelty without a new innovation. So then it starts the clock over again with that new innovation. Patent pending has a hard stop, but if you get a rejection in the mail, you have 3 months to respond. And then you have up to 3 months to extend that. So even if you think, okay, the patent office has proven that it's not patentable, we're not going to be able to get this, we're going to go another route, maybe take that application, add a new novelty like you suggested, and file a whole new application. That patent pending is going to stay in place for another 6 months. So you can still technically claim patent pending, even though eventually that original date is going to expire, and you have to start with a new date. So filing early and often is a great strategy, but that requires resources and funding. So there's always a trade-off in trying to manage all that. So claims in a patent application basically define the scope of protection. That's, I think, the best way to describe that. Okay, enforceable patent summary. The foundation at the bottom of the pyramid here is patentability search. And as mentioned earlier, it helps us understand the novel and non-obvious aspects of your innovation and whether or not it's worth moving forward with the patent application. The next level to the foundation is the claims. And the claims should include the novel and non-obvious aspects of your innovation, detail beyond well-understood, routine, and conventional, and a meaningful limit on an application of the invention. The next level is, like we talked before, accurate inventorship. Inventorship is based on the claims. So that's why it's best to start with a map of all possible inventors, all possible innovations, and hand that to a patent professional, and have that patent professional look at that again once the claims are defined after doing a patentability search, and then can narrow down that list if necessary to have the correct inventors. And then the last aspect of this pyramid is a well-described invention. Okay?
What's the difference between the patentability search and the claims? The patentability search is the database. Is it just searching in there and finding anything that could be competing? Or is it more than that? Because the claims are the description of the invention itself, and how it's used, how it's not used, things like that. But how does that interact or conflict with the patentability search?
Yeah, so patentability is a really broad search because it can include any disclosure anywhere in the world. It doesn't necessarily have to be claimed. It could be buried in someone's patent application somewhere. Maybe they didn't even get a patent on it because they didn't have something that was well described enough to teach others how to make and use it. But it still could be in their patent application somewhere. So a patentability search is very broad. We're looking all over the world for the innovation disclosed somewhere else, or something similar to the innovation, so we know how to distinguish it and describe the distinct aspects of your innovation, right? Patent claims come more into the fold when we are looking at infringing. If you're infringing on someone else's patent, you have to basically do all the things in one of the independent patent claims. If you don't do one of those things, or if you do one of those things differently enough, then you likely aren't infringing.
Okay, so claims is like the description of like these are the areas that we were protected in, and patentability. Oh, thank you. And patentability search is what you would use to find something in the world that had similar aspects of what you're doing.
Right.
Okay.
And that helps us to decide how much detail we need to put in the claims and where to focus our efforts, right? Because we really want to show what's distinct from that everything else has been disclosed previously.
Okay, and if you were doing a patentability search and you found something that maybe didn't have a patent, like you said, say in Spain, but what you were working on is similar enough to that, it would become non-novel? Is that the idea?
It could be, yeah.
Okay.
If we can't find any distinctions between what you're doing and what they're doing, then it might not be worth moving forward.
Okay.
Or it might give you direction on what else to add to your innovation to make it novel.
Okay, cool. So sorry, final question on this is the patentability search is where like the teaching other people how to like take your invention and like go further with it. That's where that section would come into play.
No,
or
so
is
the
not?
patentability search, we have to disclose anything that we find that we believe is relevant. We have a duty to do that. But the patentability search is something that we do before filing, or before maybe we file a provisional application, then do a search, and then decide if it's worth filing a full application. But it's something that we do outside of the application process. The only thing we have to disclose to the patent office is anything that we find is relevant. So in your example, let's say we find that application in Spain that was never issued as a patent, but it's got your innovation in there. You go back to the drawing board, you come back with an improvement to your innovation, and we find that that's novel. We'll probably put that Spanish patent application as a relevant disclosure along with our patent application, but we don't have to disclose all of our thought processes that went into the patentability search.
Okay, cool.
It's really for our own benefit to know what should we claim and should we move forward or not.
Okay, thank you.
Okay, patent applications versus trade secrets. So another brief legalese here. Patents protect devices, compositions, and processes. AI most fits into processes. And as we've been discussing, requires sufficient disclosure to teach another person skilled in AI how to make and use the invention. And if we ever wind up in court, enforceability might require discovery, so beyond what we put in the patent application, if the granted patent is litigated. On the other hand, trade secrets protect confidential or classified information such as formulas, methods, and hidden aspects. Aspects which cannot be discovered if infringed upon are better left as trade secrets. So what does that mean? If you have developed if your AI innovation is something that's behind the scenes that no client, customer, maybe even most of your employees will never see, then it's not worth the trade-off of disclosing that to all of your competitors. Because if they steal your innovation, it's going to be very difficult for you to find it. So in that case, it might be better to do a trade secret and not seek patent protection. Now, if it is something that you can take an educated guess that someone is using if they knocked you off, then it might be worth filing a patent application because the process of discovery would make them disclose wherever that innovation might lie, whether it's on a back-end server or something like that. So that's important to consider those differences of you're teaching others how to make and use your invention, so you want to know if they ever infringe upon your claimed patent so that you can send them a cease and desist.
So I guess my understanding is the patent protects you from someone in the public being able to come in and recreate what you've created. But a trade secret, isn't it the case that you have to be privy to the secret in order? So if someone has a trade secret and you stumble upon the same solution that the trade secret protects and you had no association with them, you don't have a trade secret violation, correct or incorrect?
Right. The trade secret violation would have to be somebody who knew about your trade secret and had a written agreement to keep that confidential and violated that agreement. That's the only way that the trade secret violation is really going to come into play.
Trade secrets are only protectable if you have like an NDA or non-compete or something like that. It's based on a different contract.
Yeah, absolutely. Okay, really quick to wrap up here, when to withhold a disclosure around your AI innovation. So in the United States, for more than 1 year before a patent application is filed, your invention must not have been described in a publication, used in public, offered for sale, or otherwise available to the public. So if you have any of these triggers, then note that on your calendar, and about 9 or 10 months after any of these triggers, make sure you engage with a patent practitioner to try to file a application to protect your innovation. If you want protection outside of the United States, most foreign nations require absolute novelty, meaning that your patent application has to be filed before any of these other public disclosures have been made. So we don't get that 1-year grace period. In the meantime, non-disclosure agreements can be useful, but they're not as powerful legally as a patent application. And then I also have a list of when to engage a patent practitioner. Analyzing results of a patentability search, determining aspects of the inventions that may be discussed with others, such as funders or customers, obviously preparing and filing a patent application or prosecuting that patent application. And then a quick note on the bottom here, patent attorneys are needed for legal matters outside of the patent office, for patent matters related to the patent office, including filing and prosecuting and appealing patent applications at the patent office. Skilled patent agents are usually more cost effective. If you're going to litigate in court, then you need a patent attorney. Okay, that's it. Any questions on anything we covered or didn't cover?
What's the price range for beginning to end on a patent? And I assume there's a range of what that would be.
Yeah. Yeah, it's very wide. So I've done patent applications in the AI space. This is just the patentability search all the way up to filing a patent application, anywhere from 12K to 50K, depending on what is involved. The 50K had lots of inventions wrapped up in it that we intended to cover through continuations in the future. But that's not the end. There's prosecution costs, there's additional fees, there's maintenance fees. So in general, it takes about 3 to 5 years in the AI space to get a patent right now, from the time you file till the time it's granted. So if we include that time and maintenance fee time over the life of a patent, I tell people to usually budget 50K. It could be less than that, and it could be more, but that's probably the average over the lifetime. So you start with a patentability search, and about 13 and a half years in is the last maintenance fee.
Okay, well, I think we're at time. We want to thank Rob for taking the time to do this whole presentation. I'll go ahead and close this because if you have any other questions, he'll be sticking around for a little longer so you can ask him those questions. We'd really like you to stay connected with us. So if you're not already a part of the LinkedIn community with the Silicon Slopes AI chapter, be sure to join because a lot of our events will be there. We're going to be having our next event on January 13th. We're going to have our Lunch and Learns resume every second Tuesday of every month, skipping December just because it's a busy month, but then resuming again in January. If you have suggestions for additional speakers, topics, sponsors for our Lunch and Learns, I'd love to hear about it. So be sure to talk to me afterwards, or you can connect with me on LinkedIn. And super grateful for Rob to talk to us about these patent issues and help you with your AI inventions. So. Yeah.